Good afternoon. Welcome and to Heritage Hills Live. We are here every fourth Friday of the month to sit with our principal attorney, Asita Duncan, for Heritage Hills Law. We are a firm that practices estate planning in the Maryland, D.C. area, and we're here today to answer any questions that come through our chat. Every month, we're here to talk about various topics and to have a little bit of fun. So today we are outside in this beautiful yard, welcoming the springtime in, and to talk a little bit about what it's like as a beneficiary. What should we do as beneficiaries? What are the steps to take? So I'll let Asita take some time to introduce herself.
Hi, my name is Asita Duncan. I'm a estate planning, estate administration attorney. I practice in Maryland and the District of Columbia. That means I help you get your affairs in order as well as to administer estates and trusts after a person has passed.
And I'm sorry, I forgot to introduce myself. I'm Dr. Teray Dixon. I'm the moderator for these events, and a good friend to Asita Duncan. So there've been a lot of questions that we get from time to time about what is a will, what is a trust, but what does it look like on the other end? If my loved one passes and I have been named as a beneficiary, where do you even get started? It's such a trying time for folks. You may not be thinking straight. What are the first steps to do if I know my loved one has worked with an attorney like you?
That's a great question. I normally say contact that attorney and also locate the documents because you
Yes.
need the documents so you know that you've been named a beneficiary, but how have you been named a beneficiary? So we need to know how have and in what mechanism have you been named a beneficiary, because then that determines what happens next.
Mhm.
And so if you know that your loved one worked with an attorney, that's a great first step.
Mhm. And we talk a lot on our live stream about getting those documents and knowing where those documents are. So I think on both sides, my loved one who's worked with an attorney should be letting me know as a beneficiary that where those documents are. We do talk a lot about that, and I get the suspicion that people don't know where those are.
That is true.
Come up in your practice a lot.
Yes. So I normally tell my clients, at least I get it that you might not want to tell all your beneficiaries that they are a beneficiary for various reasons, but at least two people you trust should know where those documents are, and they should be able to go grab those documents when it's needed.
All right, so I have the documents.
Mhm.
I give you a call. Then what?
So we're going to read it. So let's say, for instance, you're a beneficiary in a will. So with the will, we all know it goes through probate. And what I find sometimes in cases that a person know that they're a beneficiary in a will, and they just think that they can read the will and go get the item because I am listed there. But with the will, we know there's a process, and that's called the probate process. So it's the legal wrapping up of the person's affairs. So it's a process. So the person who's named as the personal representative, that's the one that's going to administer this estate. And eventually you will receive your whatever you inherited as the beneficiary. But they're going to have to go through some paperwork, procedures with the court, and all of that process before you actually receive what was left to you in the will.
Now, what if I don't want to go through court? Is there a process to avoid probate?
Sure, there always is. You can be named a beneficiary, and for instance, we'll start with a trust. So you can be named a beneficiary in a trust, and assuming that item is in the trust, upon your passing, we're still, if you working with an attorney, you will still work with that attorney, review the trust, and whoever is the successor trustee, of course, if you're not the successor trustee, but just the beneficiary, then the trustee will send you a copy of the trust documents. The trustee would administer the trust, and eventually you would receive what's in the trust, hopefully.
And are there other, is that it? Or do I have to show to the city or the state that my loved one has passed, or how do I, how do you interact with all the different financial institutions, banks, the Department of Motor Vehicles, if I've inherited a car or something of that nature?
Great question. So, a lot of times we name beneficiaries directly with a financial institution. And so, keep in mind, each financial institution have their own process of how you can acquire what was left to you. So, let's say your loved one, while they were alive, they named you as a beneficiary for a bank account or stock or 401k, whatever it is. You would then need the death certificate. And so, depending on if you're the next of kin or not, who gets the death certificate? So, normally the next of kin gets the death certificate. If it's not you, then you got to ask the next of kin for an original copy. You may need an original in order to provide it to that financial institution. And the financial institution almost always have their own process for you to prove who you are, whether it's by ID, also for you to fill out their own forms and get it. You might have to sign it before a notary, witnesses, or get a medallion seal. So it's a process. It's great to be a beneficiary, but we got to keep in mind each entity has their process in order for you to receive what was left for you.
So you brought up something interesting. Next of kin. So the death certificate goes to the next of kin. Mm-hmm. So who identifies the next of kin?
So it's normally basically by law. Like if you're married, your next of kin is considered your spouse. If you have a domestic partner, now that in Maryland and DC, we recognize domestic partner, your domestic partner. If you're a parent and you pass and you're unmarried, then it's your children. So the law looks at who's the next of kin.
Okay. So for a spouse, for example, they would have to show a marriage certificate to show that they're next of kin.
So let's keep in mind with the death certificate, the funeral home is normally the one that provides the information. So normally it's not always the next of kin that gives the information, maybe who's available when they came to collect the body and who's doing the funeral arrangements. So they may give that information. And if it's not contested or anything, then normally the funeral home goes with what was said by the person giving the information.
Interesting.
But I will say, you know your family. And so if you know that there's going to be some dispute when it's coming to giving that information to the funeral home, you should have that accurate documentation of your marriage certificate or your birth certificate, something to prove that you are the next of kin. Because sometimes that does come up. And if it does come up, then at that point, the funeral home will ask for documentation to prove who you are.
Very interesting. Very interesting. Mm-hmm. So I just want to acknowledge all of the goings on around us outside right now. So you really do know we are outside. This is not a fake background. No. This is really outside. And we have a lot of, some lawn work, some trucks going on.
And the birds.
And the birds and the bugs and all these things. So, but, whenever you join us here on Heritage Hills Live, you never know what you're going to get.
Right.
We like to have fun. It's a heavy topic,
yes.
And it's good to have some light banter and some joking and some laughter around something, because we really want the public to start to consider estate planning more, in the same way that you may plan for your retirement. You also need to plan what happens with your estate on your passing. Mm-hmm. I wanted to talk a little bit about inheritance too. At this time of the year, I think in our promo, we talked about, Easter and a reminder of what a magnificent inheritance we have received in the resurrection of Christ.
Yes.
And what a responsibility we have. So, and again, in talking about beneficiaries, what's some of that responsibility that a beneficiary has as a steward of this inheritance that someone has left them?
Well, we always hear that if you inherit a whole lot of money, the person who inherits runs out and gets what? A car.
I have that check. I got that money.
So I would say try to pause and think Yes, it's yours. You can do whatever it is with it because your loved one left it to you, especially if they left it to you without any strings attached. So that means you can do whatever you want. You can go buy that red convertible, or you can take that year off and trip around the world. But what impact could you have? Like if we take some time and pause and process and say, what could I really do?
And the responsibility that you have, you know, if someone trusted you enough with their estate, you know, what are the things that person would have wanted you to do with that money? It could be a college education. It could be, you know, passing down generational wealth, you know, not, you know, to your kids, your grandkids, your great grandkids. And is there any way that, you know, say, I know my family's not very responsible, and I know I want that estate to last for generations beyond them. Are there any ways that I can set up so that, you know, my beneficiaries are almost protected from themselves?
So we are back in the land of the trust, because as we think of a trust, it's your set of instructions. You get to put parameters around how your loved ones inherit, use, or whether they even take ownership of possession, or whether they just get to benefit from whatever you leave behind. So we like to say that's controlling or parenting from the grave, because you get to control how your loved ones get to use and have access to what you worked hard for and what you stored while you was alive. And we think about whatever we leave behind, that's the sum of, at least the physical part, the sum of our being here and what we have put our hands to do, and that's the sum of it. And it could continue doing those things that you enjoyed while you were here, and you can sort of force your loved one if they don't want to. You can force it by putting parameters around the money.
Well, not force, but encourage them from themselves, you know. It's like,
because why? Because we know better.
Yeah, well, you know, the Lord only gives us what we can handle, right? So, you know, as stewards of what the Lord gives us, we also have to protect the next generation too.
Right. And, you know, as being good stewards, we do want to you know, ensure what we leave behind is being used appropriately, properly. And you know, if building the kingdom is important to you, that the funds can also be used to do that too as well.
And then, you know, if there are children involved who are, you know, perhaps still minors, or unable to take care of themselves, you know, for whatever reason, developmental disability, intellectual disability, or so forth, what are there ways to sort of help still name those minors or children as beneficiaries, but still sort of create that cocoon of protection around them and their inheritance?
Yep, we would still be in a land of trust, so we can use, for those who don't need a special needs trust, we would just use a trust with instructions. Some people pick ages, stages when the minor can receive the inheritance. Some people do some at 18, 25, or they put terms of when they can access it. For those of our children that it needs a little bit more support and care, then we have the special needs trust, where we can put those things in with the guidelines, and that won't impact any resources that they receive, and it would just help supplement and ensure that they are cared for. And we will also think about, with our minors, beyond the possessions that we leave them, we also think about making sure that there is a guardian, because so we think about all the stuff we're leaving them, put all these rules around, but what happens if something happens to me and they're still underage? Somebody else has to care for them. So whether it's the other parent, if they're able to, if not, you also name other potential guardians in your plans.
Okay. And those guardians can help guide that minor or other child through the process.
Yes.
Okay. That's good to know. All good information here on Heritage Hills Live. If you have any questions or you want to add into the conversation, please put, you know, some thoughts or your questions in the chat at the bottom right of your screen, and we can see those questions and answer those right here on the spot. If you do have other questions, if you're watching this after we've gone live, as one of our recordings. You can also add information into www.heritagehillslaw.com and go to the comments page and add your questions or comments there. And we'll get back to you either through email or how Asita contacts her clients, or also on our next live stream, which is every fourth Friday of the month. We'll be back here again at the end of May. I can't believe it's May already.
I know.
I feel like when we started this, it was in the middle of the cold winter.
Yes.
And now, we are sitting outside in this beautiful weather, sweating a little bit because it's a little warm in the sun. But,
who knows? We'll be sitting in the pool in June.
I don't know about that.
Leisha food.
But it's really great to, have our viewers come here to our live stream and even our YouTube channel. Asita is also dropping little pearls of knowledge and wisdom on estate planning on her Instagram page. We're also on Facebook. We're on TikTok. And again, she has her website, www.heritagehillslaw.com, and where we can see your questions and answer those also right there. If you want to book an appointment with Asita, she does offer a free 30-minute consultation, or I should say complimentary consultation. She is available. You can click on her website again and make your own appointment, and you can see the times and slots that she's available to speak with you one-on-one. I think those are virtual consultations.
Yes, unless you request them in person.
Okay. And again, this is for the DC, Maryland area. Outside of that, maybe Asita can give you, I don't know, if she has referrals all over the country. It would be nice if she did. But, again, you watch some of the videos so you know what to look for, and you can sort of build a relationship with an estate planning attorney in your area. All right. So what else is on the agenda for today, Asita?
So, and still in looking at beneficiaries, if for my DC people who are out there, a lot of times you can be named a beneficiary of a house with the DC Recorder of Deeds. And so, you've been listed and you're like, well, what do I do next? So you actually have to contact the DC Recorder of Deeds, and you actually have to file a new deed. And they're going to ask you, do you have a certified copy of the original deed? So you got to have all these documents. You need the death certificate. And all of that happens outside of probate. So sometimes people utilize somebody like me, or they use a title company to help them to make that transfer from their deceased loved one to them. And it's brilliant because you don't have to administer a trust and you don't have to administer a will.
Interesting. So the deed is a critical document, and it has to be set up properly in the way that you want your estate executed, correct? Right. And we have talked about deeds in the past on our live stream. And we also have a couple of short videos about deeds and, how to avoid that DIY deed temptation.
Yes. A couple of $100 will save you a lot of time and money. I have a hearing that's going to be coming up in May. And it's for somebody who did a DIY. They did the deed themselves. They got the deed form and they just filled it out. And they just naturally assumed both names were there, that when the other person passed, they would inherit. What they discovered was these deed forms don't tell you how you hold property. So it's automatically treated as tenants in common. And if you've been with us before, we know tenants in common, if one person passed, that person's share is split and it goes through that person's estate. And so in this situation, we're talking about two domestic partners in Maryland who wasn't registered. That's another thing. So they wasn't registered. So, and since they wasn't registered there, she's treated like a friend. So she is not legally entitled to his 50% share. based on the law, but we're gonna have to hear about it and see.
So that's interesting because a lot of people think that if they've lived together for a certain period of time, then there's this term common law marriage.
No, every place doesn't recognize common law marriage, and even those places like, for instance, DC that recognize common law marriage, nowadays it's hard to prove.
Wow.
With all the other options that you really intended for it to be husband and wife. Yeah.
Wow.
It's always better. Put a ring on it. Put a ring on it. Put a ring on it. Because then you don't have to guess and have to see people who intended to be quasi married, but then they, it's treated as a friend and they may have to leave the home. Yeah, it can be.
Talk about life changing.
Yes.
Wow.
Yes, at 60, 70 years old, discovering that you lived together for 34 years and thought that you were living according to whether a common law marriage or you thought you was a domestic partner, to only be treated as the law doesn't recognize you as nobody but the friend. Oh. And to add another layer to that, if your partner didn't have a will or anything listing you, then their legal next of kin is entitled.
You don't have any entitlement to it unless you're in those documents.
Yes.
Wow. Mm-hmm. So if the family wants to, I guess, contest something that, contest the beneficiary. So say, my loved one has put my name on all of the documents. I'm named in the trust. And that person's family doesn't want me, disagrees with that decision. Mm-hmm. What happens in those cases?
So if we talk about a will, then the person has to file a will contest. So they got to object in the probate court to that. And then it goes through a hearing. It can be expensive and costly. So it's always best to resolve those type of family disputes while everybody is alive.
Stay out of court.
Stay out of court. If you can. You can if you plan in advance, hopefully. Mm-hmm. With the trust, it's not necessarily before the court, but if the person has can bring it before the court by filing a petition and bringing it into court and let it air out in court. For you see it also in like insurance policies and different stuff, and those financial institutions have their own mechanism to get that, if you're objecting, to get that started. And depending on who you are that's objecting, you may have more rules and rights through the court than somebody who's just a friend or another family, because spouses, you can't disinherit your spouse. Yeah. So they have a little bit more leeway to bring all of that, depending on your jurisdiction, in court. Yep.
Well, I think the message of the day is avoid court.
Some people can, and some people,
sometimes it can't be avoided. But if it can be, putting those, as we said, we are out here outside and the bugs are coming. But, just to make sure that your estate is planned well in the way that you want it executed. Beneficiaries also have a certain responsibility. So we want to choose those people that we trust to be good stewards of their inheritance, and executing and trusting other people if we have young children or adult children who aren't necessarily able to live on their own, and have a trusted person to help them along the way. Yeah. So I don't see any questions in our chat, but I just want to remind everyone again, we are here live on YouTube every fourth Friday of the month. Please like and subscribe. If you are seeing this after we've gone live, please put your questions. It's never too late to reach out to us. You can schedule an appointment, a 30-minute consultation that's complimentary. And we can also answer your questions if you put them in the comment section on ACETA's website at www.heritagehillslaw.com. All right. Any last words, ACETA?
Plan. It's always best to plan because without a plan, who knows? It could work, but more often than not, it doesn't work.
Yes.
Yeah.
All right, everyone. Enjoy spring. Enjoy this beautiful weather, the sunshine. We know everyone's being attacked by pollen right now, but that's going to go away pretty soon. And thank you for joining us. Again, please like and subscribe, and we will see you next month. Bye.